My lady, I call up the matter of state versus Zuma and another, PCB 30 of 2018.
Please the court, my lady, I appear for the state, together with my friends Ms. Kutsia and Mr. Mtendwa. Please the court.
As the court pleases, my lady, I appear on behalf of Mr. Zuma, the first accused in this matter, together with Ms. Thales, Mr. Mutsipe and Mr. Skakane, briefed by Mabuza attorneys. As the court pleases.
May it please the court, my lady. Ms. Jackson and I appear on behalf of the accused number 2, that's Thales, and we're briefed by Herbert Smith-Friels, and the 2 attorneys are present.
Thank you, my lady. My lady, I'm going to unmask while I address the court with the court's permission. Thank you, my lady. My lady, might I just begin with some housekeeping matters and say that there's been a flurry of papers between the state and the defense and the court leading up to today's date. And so ultimately what forms the basis of the state's position today at this pre-trial hearing are the following papers, and that is a letter to yourself, my lady, a letter to you which we lodged yesterday, which sets out the position of what you have to determine today according to us. And then also the state's revised pre-trial minutes, which we also served upon the registrar and your ladyship yesterday. And then also the reply to Ms. Mabuza's request for information, which your ladyship directed to the parties. And so those 3 documents really encapsulate what is before the court today according to the state and what your ladyship has to determine. So I'm assuming then that your ladyship has those papers before the court.
Yes.
May it please the court. My lady, and in particular, the letter to your ladyship sets out what summarizes at the end what we think the court has to determine today at this pre-trial hearing, and that is, number 1, the proposed timetable for the exchange of papers to a further holding date. And I'm now looking at page 4 of the letter to your ladyship of yesterday.
Do you know what the headline, the heading of that letter is, Java?
Yeah, it's a letter to your ladyship dated yesterday, the 22nd of June, from the Director of Public Prosecutions, Ms. Zungu.
Yes, I have.
Right. So I'm now referring to page 4 of that document, my lady, where we say, because your ladyship asked us to indicate to the court what we say the court should be dealing with today.
Yes.
And this is what we say that you should be dealing with. And that is, they're on little emphasis points. The proposed timetable for the exchange of papers leading up to the next pre-trial hearing, because we're all agreed that the matter today will be postponed to a pre-trial, another pre-trial hearing, what the next holding date will be, the issue concerning the Judge President's continued pre-trial management role in this matter. We have submissions in that regard, and whether it's feasible now to talk about a possible trial date prior to the matter being certified as trial ready, which it has not yet been, and then a discussion about and directives about the state's proposal that the earliest practical trial date is the first term of 2021 for all the reasons that appear from the application and from the further exchange of papers, which sets out the position fully. So that is, according to us, my lady, the framework which governs what the court has to determine today.
May I just inquire, is the state, except for responding to the request for further particulars and any possible further requests therefrom, is the state ready to proceed with this trial?
Yes, the state is ready, yes.
Right now?
Well, my lady,
If I were to direct that this trial had to proceed in October, are you ready?
Yeah, because one of the points is that being ready doesn't mean that we could come tomorrow and start the trial. In a matter of this sort, and
yes.
Any High Court trial, you need an appreciable, reasonable time from the postponement from the last pre-trial to the actual commencement of an actual trial date.
Okay.
So once we know that the trial date is certain, then we need time to get our ducks in a row. But certainly if it were to be postponed today for trial to October, then the state would be ready in October.
Okay,
Were it not, And we've said that all along. We've never deviated from that position.
All right.
We know who our witnesses are. We know where they are. We know whether they're alive or dead. Our documents, etc., are ready. So the answer is yes.
But you have a problem there, wouldn't you? You have international witnesses, and we don't know when the the restrictions to international travel will be lifted. Do we know?
We don't know. And so, my lady, that brings me to the last point which I would have made in summarizing what's going on today, and that is really, let's just take it back to where we were in February,
Yes.
at the pre-trial in February, the 4th of February. We'd heard of COVID. It wasn't really affecting South Africa. There were all sorts of prognostications that it might. We didn't really take it seriously. We thought things would continue as normal in this year, 2020, and we'd all be accessible, able to travel, able to consult internationally, etc. What happened after the 4th of February is that Mr. Zuma was sick. He was unwell. So the matter, against our advice, against our wishes, because he estimated that he would be away for some time, at his request, we postponed it to the 6th of May. It was far too long. We would have
So one can't have any control over illness.
we have no control, and we accepted that, and there wasn't a fight about that. We
Yes.
accepted it. We fought about the documentation, but apparently that's going to be rectified today, I'm happy to hear. So I don't think that's an issue anymore.
No.
Nevertheless, with reluctance, May came along after February. That's 3 months. February, March, April, May. It's actually in the 4th month. It's too long for us. In that interim period, South Africa was hit by this unprecedented worldwide pandemic. Totally unpredictable. We have no control over it. And that affected us and everyone seriously. So when May came along, we had a virtual hearing. We had an in absentia hearing, and not of our choosing. The point is that it was then postponed from May until today. Again, we were uncertain whether we'd be able to sit today. We were uncertain about everything. We're still uncertain. But nevertheless, because of the issues which have arisen, we thought it best to ask your ladyship to have a hearing, and we indebted to the court that the court has done so. But the COVID is all pervasive. It's not an excuse. It does seriously affect everything. It affects our ability to travel, our ability to meet, our ability to meet our forensic people, our ability to meet and consult with our witnesses.
But local travel, the restrictions for essential services has been.
They've been lifted only
Yes.
recently,
Yes.
yes, but not in the period from when in March, at the end of March, I think it was, until June.
Yes.
We couldn't travel. We couldn't even meet, except for virtually. And this is a documents case involving containerfuls of documents. We often have to have access to the original stuff.
Right now, I see that you have furnished all documents to the parties. So is there anything outstanding?
No, only what they require. And they require, by way of further particulars,
Why is it, according to your note, you'll only be able to hand over documents to the second accused by the 17th of August?
Yeah. Because, my lady, first of all, what they want, it's not the docket, it is all documents which the state has ever taken from anyone, as I understand it, in this case, including computer hard drives of numerous computers and other devices which we took. To do that, because it was stored electronically in a database many years ago, but more than a decade ago, to transfer that document into a form which we can use and to give to the defense is a process.
Oh.
And that process is very difficult because it's old technology and it has to be updated.
But you've given a date, a
They've been-
definitive
yes,
date.
Yeah, they've been appointed. That took longer because of COVID. They couldn't work because of COVID,
Yes.
et cetera, et cetera. We put it all in the papers. But they are appointed, they are working, and they've given us a date.
Okay.
And that date in itself it's unpredictable because the process itself it takes processes which are not able to be determined how long. But they've given us an estimate on percentages of what they've already completed, and that seems a feasible date, and we are moving heaven and earth to make sure that date we will comply with. And if we don't, we will approach the court, etc. But that is the nature of pre-trial. But in short, my lady, that is one of the things which is holding up. Otherwise,
What about the request for further particulars by Mr. Zuma, or on his behalf?
Yes.
That has been furnished or requested from you.
Yeah, my lady.
When will that be? Do you have a time?
Well, that also in the proposed timetable, which I've given to your ladyship,
Okay.
that is allied to the database which we have to give to Thales,
So
and it's
17
also
August as
it's also
well.
allied to other forensic procedures which are forensic accountants, which are different to the technical forensic team, which our forensic accountants have to do at our request in order to answer the questions and find documents which are not in the docket and which we have to give to them.
So if the way I see it, there's not much outstanding in this matter then,
No,
depending on any further requests that might
no,
arise.
it's, yeah. It's just, yeah.
So, you know, in the light of what the objections to protracting the trial, and it's quite understandable, the first accused is his advanced age, that one would want this trial to start and end as soon as possible. It's in the interest of justice, I think. So, in the light of the stance taken by the defense, well, the first accused, can a date not be set in August for a proper certification date, and then depending on the restrictions, etc., depending on that, whether a trial date cannot be set within this year? Because I was considering this. You have South African witnesses who can be available until the restrictions are lifted.
That is correct, my lady, yes. The trouble with the August certification date
Yes.
is that we will only have given Thales by the earliest, the 17th of August, what they want.
Yes.
We will only have answered Mr. Zuma's particulars by a date after the 17th of August and Thales.
Yes, no, I wasn't suggesting the 17th. I was
Yes.
suggesting towards the end of August or perhaps even the early September.
Yeah, but the trouble is that we will only get after that date the further request from Thales for their further particulars based on the information which we give them.
That's if they are going to request
Yes.
that.
So if we're going to get that application, then we will need to answer it. And what we're saying is that period of the end of August through to September,
Yes.
we will need to give them the information which they want. And Mr. Zuma, well, we hopefully would have already, and also Mr. Zuma, because it also depends on that information which we get from our forensics.
So do you anticipate that it will take a long time to respond to that request?
Well, hopefully, because the forensic stuff would have been done, it wouldn't be as long as it's taken up to now, because we've had to commission the extra work and do the extra work.
Yes.
So it should be shorter.
All right.
But given, I mean, we've got 56 pages from Mr. Zuma on the 19th of June. That was on Friday. We're now on Tuesday. And we don't know what the nature of the further information will be that we get from Thales.
Yes.
But we will certainly endeavour. But it would be foolhardy to think that by the end of August, the court would be in a position to certify the matter as trial ready.
Trial ready.
Because we'll be in the process of exchanging papers. And usually in these matters, my lady, there's a further exchange of papers because they're not happy. And there's further engagements, and we have to then get to a point when we eventually ask the court to determine who's right and who's wrong.
Thank you.
So ladyship will be aware of that.
Yes.
Yes. So Mary, that is why the timetable it's just if we bind ourselves to the end of August and say we will have answered and they'll be happy, and we get here at the end of August we're not, then my learned friends will say now we're not complying and we're part of some conspiracy to prevent him from going to trial, which is not at all the case. We want to avoid getting to the point where, pushed for time, we make all sorts of promises, and they make all sorts of promises, and we can't keep them, and then it looks bad. And, my lady, if I could just take the court back.
Yes.
This matter's been on this court roll since 2018. Right. Prior to that, it was on this court's roll back in 2006.
Yeah.
There's been the exchange of papers, there have been applications, there have been various court judgments, etc., etc. Now, in this most recent period, Thales at the beginning of this year, to some extent, Mr. Zuma, only now on the 19th of June, 2020, has finally entered into debate on the merits of the case, has read the docket, has read the forensic report, and has asked us questions about that. And they've had that indictment, the forensic report, in another form since 2006, the updated report since 2018. So my learned friends are somewhat, I would submit, unfair to say, when we ask you now for all this material, you're not giving it quickly. They have had since 2006 to ask us for this material. If you ignore the interim period.
Could you request persons to turn off their phones?
Yeah, thank you, my lady. So the point is that only now, in June 2020, are we entering into the preliminary stages of a big High Court commercial matter.
Yes.
Normally, if this was the first appearance of a big High Court matter and we entered into this matter, it would be very unusual that the trial would be set for October. It would be very unusual with this number of witnesses, the complexity of the case, the international flavor, the exchange of documents, etc. So to expect that in this case, October is a reasonable date when we know that the certification process is not yet completed and it's uncertain, it just doesn't make sense. And we said in this very court before your ladyship's late brother at a stage that when we were similarly pilloried for not being able to start a trial on the date when we said that that was a trial date. And I said, you know, my lord, the state, when we set dates, when we set targets in good faith, etc., we take chances because we expect that processes will be completed, that we'll be ready. But obviously, in certain circumstances, events overtake you and you're not able to comply with your promises. So the only point I'm making is that we don't want to get into a position where we overpromise and underdeliver. We want this matter to be handled properly. We will do everything in our power to make sure that the matter is pre-trial certified at the earliest possible date, which we propose is October. August just doesn't seem to be a date which is attainable. And then on that date, once it's pre-trial certified, and that's not our choice. It's a pre-trial directive that the Judge President has issued in 2018, and most courts adhere to that, is that before a trial date can be set, it must be certified pre-trial ready. And I think that the JP had in mind avoiding these silly situations where everyone is promising to go to trial, but all the pre-trial stuff hasn't yet been done.
That's exactly how it's done in this division.
And I hope it works well. I understand it works well. And in this matter, I think it's perfect for this matter. It's absolutely perfect. Because it's not correct to start talking about a trial date when we're not 100% certain about the pre-trial certification process and when precisely that will be. Of course, we can all talk about when we think we're all ready. Of course, it's correct that my learned friends and I, as we have done, talk in theory about, are you ready in October? What would October suit you? You know, are you available in next year in February? What is your position? You know, is that if we'd all agreed and said February is a great date, we could have just done this virtually and agreed to postpone to a pre-trial later this year and then all gone on in February. Of course we could do that.
Okay, I think you've made your point.
Yes, thank you, my lady.
All right.
So I'm assuming then that the court has read all my papers, and I'm not going to develop it further than that, other than to say that and this is a central incoherency of the papers in our respectful submission from the defence. They blame us for not being ready. We've told the court, we've told all the courts we are ready. They have, what's holding us up now is their request for further particulars, right? And I've addressed the court on that. That means, logically, unfortunately, that it is they who are not ready to go to trial because they say they do not have sufficient information. They want more information, they want further particulars, they can't plead, they're not ready to formulate their defense, and they cannot come to court on an appointed trial date, as we would prefer. Plead plead not guilty, say why they plead not guilty, and then we proceed with the trial. They say they can't do that. And that's fine, they're entitled to do that, and it happens in all courts. And the procedures as to how that's done and that it may be done is fine.
I'm going to hear what Mr. Skakani and
That's our point.
Yes.
That, and it's an ironic point because we've been pilloried as the bad boys in this now. And yeah, just to emphasize the point that in January this year, we in fact invited the parties, including Mr. Zuma, please start engaging with us. Give us the further particulars. Mr. Mancha, on his behalf, declined. He actually, in writing, said we won't, and for various reasons. But anyway, he wouldn't. So we did try to get them going earlier, but 19th of June last week was when they responded. So yeah, and then just on a practical level, just to give your ladyship some examples of the effect of COVID, it's not an excuse. We plan a meeting for this week precisely to address all the issues which worry my learned friends. All counsel are available, forensics are available, the police are available. We can't get a venue because it's all the venue, or some of the venues that we plan to meet in are being sanitized. The forensics have just informed us that they can't meet us for 14 days because they're all in quarantine because there's been some exposure. The head office in Pretoria of the National Prosecuting Authority was locked down now until I think today or tomorrow because of COVID. And so it goes on, the police and the forensics, etc. So these are, in this time, at the height of the pandemic, totally unpredictable.
Yes.
If we were to come to court in August and say we couldn't deliver on the 17th of August because the forensics people couldn't go to their offices because they had to stay at home and they couldn't meet us and we couldn't reach our planning goals, etc., because of COVID, what would the result be?
But we have to set dates.
Of course we have to set dates.
And we have to take it as it comes.
But all I'm saying, my lady, is that when we say that COVID has had a marked effect,
I think we all can take note.
It has,
yes.
And we have no control. We'd far prefer that it didn't. And we would be further ahead were it not for that. And the problems we would in all likelihood maybe have all agreed on October.
So Downer.
Thank you, my lady. So that's all I have to say.
Further points?
No. And we did have a draft. I've got the draft order, and your ladyship will address that
Yes.
if that suits the parties. May it please
Thank
the court.
you. Mr. Skakani?
I'll do the same. I hope it will be safe for everyone.
Yes.
Well, let me start with an administrative issue. When Mr. Zuma fell ill in February and had to go to Cuba, the learned judge at the time sort of disbelieved the letter from the doctor and issued a warrant of arrest. But to put that matter to bed once and for all, we've tried to get the doctor again, who was disbelieved, whose note was disbelieved, to do it again to indicate that Mr. Zuma was indeed in Cuba and he was ill. I beg leave to hand it up, and I hope it puts the matter to bed.
Okay. Has a copy of that letter been handed to Mr. Downer?
I had asked that it should.
Because,
I showed him I've got it. I'm going to read it.
As I understood it, he hadn't seen any documentation in this regard.
I just put on record that this is the first time I've seen this letter, despite having asked for it twice from my learned friends. We'll peruse the letter, but in principle,
Yes.
it wasn't that the certificate was disbelieved. It was just that we, the state, and I think to some extent the court, found it insufficient. That's all we wanted was full particulars that satisfied.
So if this document is acceptable, then it simply means that the warrant of arrest is then cancelled
Yes.
today.
And this court, in terms of section 170,
Yes.
in brackets 2, may hold an inquiry. The nature of that inquiry is...
Well, if the state is not, it does not challenge the contents, then there really is no need for an inquiry. The court is then satisfied simply on presentation of this document, if it's not challenged, that his reasons are as set out in that document for not attending court.
On a perusal of this document, it doesn't seem to me to be problematic in any respect.
Okay.
So
So do you still want to deal with it later, or shall I put it to bed now?
I think your ladyship can put it to bed now.
Okay. Mr. Skakane, the warrant of arrest is cancelled.
As the court pleases.
That's please.
And now that that issue is behind us, I plan to deal with two issues. The first is just to set out the facts that Mr. Downer summarizes, to set them out from our point of view, and to indicate to you why we're here. And to the extent that your ladyship properly asked us, 3 senior counsel, to resolve this problem, because we wouldn't be here.
Yes.
It's a shame that the 3 of us couldn't.
It's just, I was concerned about the exposure.
Absolutely. It's something 3 senior counsel would have agreed about, but I'll try and explain to your ladyship why we're here and why it couldn't be resolved. Exactly 743 days ago, Mr. Downer stood where he was standing. Not just once, but I'm quoting one incident. 743 days ago, he said to this court, the state has always been ready. He said on the 8th of June in Durban, the only problem stopping this trial is the fact that Mr. Zuma does not have his house in order. Those are his words. On the 23rd of May, 2019, his senior counsel that he had briefed then, Mr. Trenghoff, said, and I quote, Mr. Zuma's strategy has cost taxpayers' money 16 million rand to 32 million rand. Mr. Zuma has been engaged in luxurious litigation designed to delay the trial. I'm quoting 2 incidents. I think Mr. Downer himself will know that he's said this on countless occasions. And it's not just him. It's him, it's the NPA, and it's excitable spin doctors over the years. The second point I wish to make to your ladyship, Mr. Downer stands up today and he talks to your ladyship about COVID-19 and a couple of things. Mr. Downer's reasons are shifting as he moves. And I'll set them out for your ladyship since the correspondence reflects it. First, on the 29th of May, when we decided that let's stop this. Let's stop this narrative that Mr. Zuma doesn't want his day in court. That was the 29th of May. Let's come to this court and face it. That's because we believed that Mr. Downer was honest and correct, that he was ready. We are ready. Now, he isn't.
Well, I understood from what, I think the very first question that I asked him, are you ready to proceed with the trial if this court were to direct that this matter proceed in October? And he said yes.
My lady, we're hearing that for the first time. If you go to the correspondence and his timetable, this is the problem, that Mr. Downer sneaks in a timetable that nullifies the fact that we say this trial must start. The last issue I'm going to deal with is a solution I would have provided if the 3 of us had been sensible enough to discuss it, which I think, because your ladyship today has to decide an approach that is less prejudicial to each one of us, to all the parties. And I'll try and provide a solution that we find in the law that can help this court to decide this matter today in a manner that befits the unpredictability of circumstances that Mr. Downer is talking about. One of the letters that came to us from Mr. Downer was a letter in which he correctly records that I had had a discussion with him. And he had had a discussion with my learned brother and friend, Mr. Roo. Well, let me complete that discussion against my own judgment. Let me complete it, because his is not. Because it explains the context and the reason why he's here. He is correct that I indicated to him that we are ready to start now, Mr. Downer. You've been calling us for 15 years. But it would be unreasonable to do so. We think let's do August and then maybe October. because we thought the state that has been running a narrative together with everybody else that Mr. Zuma doesn't want to come to court can't give us one single reason of not proceeding. Well, let me complete my discussion with him because he started it. He notes it. One of the things Mr. Dana will say to me, he will remember this because it's a phrase from him, and that's why we're here. He said, I do not want another Judge Msimang situation. That's a phrase, and then I invite him to contradict me. And then from that day,
Sorry, I'm not understanding that.
he says he doesn't want another Judge Msimang situation in which a matter is struck off the roll or removed.
Oh.
Those are his words. And I'm doing that because he started recording what we spoke about. And so basically, the context of this matter and what we're doing here and all the circumstances that Mr. Dana is doing, we all gathered here today to save face for the state that ran an incorrect narrative. And I said to him, we will insist on a date that is reasonable, and which is October. Fortunately, my learned friend, Mr. Roo, is flexible about it. Another issue arose, I know it's not before the court, was the fact that at that point we had been dealing with the GJP, the Deputy Judge President, Madondo, and all of us were communicating with him. An issue arose which caused anxiety with Mr. Zuma. And that issue was the fact that on the version of his letter, Mr. Downer, his letter himself, it's not that we're questioning the role of the Judge President to manage a matter, or we're questioning that the state is dominus litis in a matter and therefore must take charge. No. We recorded that our client is unhappy with a telephone conversation between Mr. Downer and the Judge President. And it's not just that we're unhappy that they spoke, because maybe they do, as they say, it's in the ordinary course that they phone judges. We were unhappy that if you read that letter itself, it discloses to you that they did not discuss just matters of an arrangement that Mr. Downer may want us to believe. It's clear to us that changing and amending an indictment was discussed. And so that issue is not before you, Your Ladyship, but it arose and it brought us here.
I've seen the correspondence.
Absolutely. And we will deal with it. And the last question in that letter that we have asked, the JP has not answered us. We will wait patiently. Mr. Downer doesn't. He tries to answer for the JP. We've asked again, was that the only discussion between them? Because we don't want to rush that issue, we await their answer, because we will take it further from there if that was the only time they've had this discussion. To come back to the business before Your Ladyship.
Okay, just on that point,
Yes.
On the assumption that you will not receive a reply, what will your further action be?
In respect of Mr. Downer or in respect of the JP?
Well, they both affected by that concern that you raised in your letter.
Well, I will take instructions from my client, and I think in respect of the JP, we could well let the matter go. We could well report him to the Judicial Services Commission. We could well report Mr. Downer to the NDPP or the Legal Practice Council. But I don't have those instructions at the moment, and I don't want to anticipate what my client will want to do. But we do record in this matter that we find that inappropriate.
Yes, you do record, but you've also requested that you request a direction from this court on the further, the continuation of the Judge President in dealing with this matter. And I think you will accept that this court doesn't have the power to make any order in that respect or direction in that respect.
My lady, I wouldn't like to burden you with
Yes.
deciding that. It's not
So,
before
so then
you.
I
and I don't think it's
you
an
won't
issue.
persist with that.
I don't think it's an issue you should
Okay.
deal with at all.
But that was in the paper, so that
Yes.
is why we can put that to bed as well.
No, it's all right. I don't think it's an issue
Okay.
for you to decide. What you are to decide today is to take into account what I call the state's ever-shifting goalposts about the reasons. If you look at let me give you 3 reasons.
Yes.
They're not mentioned today. In one of Mr. Downer's letters, he blames the delay on, yes, COVID-19 has been consistent with it. He then blames the fact that he thinks Mr. Mabuza, my attorney, is new in the matter, needs to read, something we find odd. He then talks about Thales and their requests for further particulars. And then the alarming one is that he says the fact that we have not given them further particulars is a delay. And today, the fact that we've given him further requests for further particulars is a delay.
I think his concern was the fact that your request for further particulars only came last week, 19 June, despite the fact that you were aware of this matter for a long time.
Well, practically, I don't have to remind Mr. Downer this. He tells us himself he is continuing with the investigations. I don't know what they are. And of course, the only time a decision was made that all the appeals that were going to happen would be abandoned is the 29th of May. Mm-hmm. And quite fairly, to think we were to focus on all the appeals of a permanent stay and focus on the trial, all of us could not do so.
So effectively, you said that until the 29th, you were focusing on all the other applications.
Absolutely.
So only from the 29th, you were able to focus on the trial.
We've always, in the past 2 years of my life, I've been focusing on that application.
Yes.
And until we took the decision. And so, in the short period we've had, not 15 years he's had, I've not been in this matter long, since 2018. I have had to read more than 4,000 pages because I'm trying to accommodate a state prosecutor who's been saying more than 7 times he's ready. And we've had to do that. I've had to increase the team. We've had to do that at our own cost. He has the taxpayer paying him to come here at our own cost because we're dealing with a man, the state, his state, refuses to fund. And so, one of the prejudices we deal with here in the timetable that he proposes, which I want to change his timetable slightly to suggest what I think suits all of us. Your ladyship will have to decide today, as I said at the beginning, what is less, and I'm not saying not prejudicial, less prejudicial to all of us. Mr. Downer sets a timetable that he knows, right where he's sitting, he knows it very well. It suits his preferred date of 2021. Whatever rationale he gives, all he is doing is an egg dance to get to 2021. We say, we are ready now.
Well,
But we are ready.
You can't be ready now.
Yes, I'm saying
you still have to receive your response to the further particulars.
absolutely. I'm getting there.
Okay.
So when I say now, I don't mean as I speak.
Yes.
That's why we give him the date of October, because we believe that even our 56-page particulars that he's talking about, maybe we underestimate how long it will take them, but considering how long it has taken us to deal with this matter in the shortest space of time, we assume that a man who's been seized with this matter for almost 2 decades would be able to answer the questions that we're asking because they relate to the charges he formulated. So in 2 days he could do that, but we said it would be unreasonable to tell the state, let's start in July, let's start in August. We understand that the state and all of us need more time. And so October for us, and I think for Thales, but Thales is also flexible about next year, is a reasonable time. We are here because Mr. Downer was not happy even about that. Now, let me agree with him about the unpredictability of what he relies on, which is COVID-19.
You see, that's a concern of this court as well.
Yes.
We don't know when it's going to peak.
Absolutely.
And then to conduct a trial in open court might expose a lot of people to the virus,
Absolutely.
which we have to guard against, and especially your client because of his advanced age.
But, my lady, you talk about my client. He comes here when I was doing a permanent stay for 5 days. He sits here, and I tell him it's motion proceedings, but he believes that the judge must be respected, he must come. I told him today that he doesn't have to come. My client believes it is disrespect to a judge not to come. And so we are here today risking him and every other person because Mr. Downer couldn't get his way. That's really why we're here. We could have agreed. He says this morning he doesn't have a problem with October, but we don't have a problem with October, so why are we here? So I'm saying, my lady, it's disturbing that the state has been running this the way he's running it, and his shifting reasons are worrying to me because it means we're unable to trust each other about what we're saying because they keep shifting. But there is a way out that I would like to suggest to your ladyship. Because if we have another holding date, and I'm going to say this to the probably embarrassment of my client about this, is that all of us here come to this case for the past 2 years at our own cost for a pensioner who can't afford it. We are not paid. We come here because we believe he deserves justice. To come for another holding date and for another holding date may prejudice him and us about costs. And in section 342A, my lady, that is accommodated. And I want to suggest that to avoid that kind of prejudice, we take an option that is akin what section 342A 3C proposes, in which case Mr. Downer is in the best situation, but all of us are not too prejudiced, is that he talks about, correctly so in his letter, about uncertainty, and I agree with him, in the unpredictability of this situation of COVID. Now, if we all agree about that unpredictability, what I suggest is the best route to do, and it leaves him in the driving seat, is that rather than prejudice all of us with another date and another date, if the court can't accept what we are saying, which is we come back in September, they file an application to postpone if they can't be ready for October, but that may be unreasonable to him. Well, your ladyship has another practical decision to make today, and it suits all of us, is because of the prejudices I've mentioned, and section 342A covers them, I would call upon your ladyship to ask, well, to order that the matter is removed from the roll. Because if you remove the matter in terms of what is akin to 342A 3C.
Yeah, but you can't do that without an application,
Well,
a substantive application.
well, absolutely.
You've not made such an application.
I'm glad your ladyship, because that procedure isn't there. It's exactly what we're saying. That's why I'm saying what is akin to what is there. Mr. Downer comes here to seek postponements, but actually he doesn't want to put up an application for the postponement. Right? We've invited them. We've said, well, our suggestion is that we come in August, which is prejudicial to us, but it's fine if you realize Mr. Downer knows sitting there that he wants 2021. There is no, we should stop playing games about what we're doing this year. He wants this trial, contrary to his statements in the past 15 years, in 2021. That's what he wants. All of this dance, we're being insincere with each other. So, what we propose is that if this matter is struck off the roll, Mr. Downer can come back yesterday, can come back tomorrow, can come back in October, in November, in January. It actually leaves the matter in his hands.
But, Mr. Skakane, I don't know why we even have to go down that route, because he's already indicated he's ready to proceed with the trial. So on what possible basis can I have to strike a matter that is ready to proceed off the road?
My lady, I'm suggesting that, as I said earlier, I did not know that Mr. Downer does not have a problem with October. We are here, we've flown
He
here.
said it's
recently.
not the ideal situation,
Yes.
but if the court were to direct that this matter proceed to trial,
But
he
in
has
October.
to.
My lady, if that is the case, because that's the position that we've put to him, if he agrees with that position, we are happy.
But we have one problem, and that is before the matter can actually be set down for trial, it has to be certified trial ready,
Yes.
which cannot be done today because we still have the outstanding issues to be resolved, the further particulars, and perhaps a further request. So until that is done, we still have a problem.
But, my lady, that is why
This court cannot set the matter down for trial today. The court can give directions as to when the further particulars can, should be responded to, and dates, and then set a matter down, well, maybe not as requested by the state, but a date that is suitable to all the parties for the matter to be certified trial ready. And on that date, whoever's dealing with the matter then can decide in consultation with the head of the court, obviously.
Lady, I don't know what the debate is really. That was our original position, that we come in August so that we can determine whether we're trial ready. He will know we are.
Yes.
If that's the position he now wants, we're happy.
You happy with that?
There was no reason to come to this court. If he could have called me, because that's the position we told him.
All right.
So we propose that we take that position, which was our original position, and if the state wants a further postponement for the reasons, we may well agree with them. I think, as your ladyship tells me, that in order to do an application for what I was suggesting, which was just a solution,
Yes.
well, I think the state, my request would that really after 15 to 20 years, the state must be able to put a substantive application and stop avoiding being on oath on its reasons, because I think that's what we're dealing with at the moment. But
The other aspect is, in your papers, you raised the issue of an application in terms of 6.1. That is not how we deal with applications in criminal trials.
I don't know. I think
It's in the papers.
it's in the papers.
Okay.
Definitely, I think it's
All
an
right.
error. But our suggestion is exactly the
I mean,
position that
it's,
was.
sorry, Rule 6.1
Yeah.
of the Uniform Rules. We
Absolutely.
don't deal with it
We
that
don't do
way.
it, no. Our position is exactly as has been stated, and I'm happy that Mr. Downer agrees with us at last that it can be in October,
Okay.
as the court proceeds.
Thank you, Mr. Skakane.
As the court pleases.
All right. As I indicated to you, Mr. Skakane, before you sit down, I cannot adjourn this matter for trial in October, because that will depend on whichever judge is going to certify the matter trial ready. There are lots of issues that have to be resolved, example, any admissions from the parties, etc. And only once that has been resolved can the matter then be certified trial ready. And thereafter, it will depend on which dates are available in this court for this matter to be set down. So there's no guarantee, or I can't give you a guarantee that October will be that date. You accept
Lady, I
that?
accept that you can't give
Okay.
me guarantees.
Thank you, Mr.
As the
Skakane.
court pleases.
Mr. Roux?
Thank you, my lady. If I, on behalf of Thales, may start with our default position that we made clear from the beginning, whether it is October or whether it's September
Or January?
or January, and whatever date it is, we will go with the flow. But I think we have the responsibility to put certain aspects before you in your overall consideration. Not that I think it will make any difference today, but at least that it is on record.
Certainly.
And that is, there is mention of a racketeering application, if I may call it this. And it says that we would issue that before the 7th of July. I can tell you now that we will issue it long before the 7th of July. It is 99% ready. It deals with the specific aspect. I'm not going into it. I've had discussions with Mr. Downer, and it deals with just a specific part of the indictment on racketeering and whether it was competent to institute it. But it's something that we want to be resolved as soon as possible.
Has it not been resolved yet?
No, it must be an application.
Okay.
But the application where it says before 7 July we must issue, we will issue long before that.
Okay.
We're pretty confident that we'll do it in the course of this month still. It's only the 23rd today. We should be able to do that, to get that out of the way. The second outstanding issue is this, and because you can rightfully ask, Thales, why have you not put in your request for further particulars? It's not that we sat back. When we worked through the docket, we realized, and I'm not going into the merits, I'm stating a cold fact. We realized that in respect of many payments, it used to be called the 783 payments, allegedly made between Mr. Sheikh or on his behalf to Mr. Zuma or on his behalf. We realized that they say that we common purpose to it, and that the common purpose was on the basis that we're aware of those payments. So we searched through the documents to try and prepare, and we couldn't find those documents. So we didn't sit back. So we requested already in February, 21st of February, followed up on 27th February, and on 12th March. We say, please give us the documents dealing with that. We can't find it. If it's in a docket, we must please identify it. And that's when we get back a response to say there would be further forensic investigations. We don't know if the forensic investigation would be there to put it in proper order or whether it's to go and search for it.
I think he gave us an explanation of what's happened. It wasn't in a format, I think that was,
I
could be easily distributed. So.
Yeah, I think there were two requests. One is the request was, please let us have all documents that you did not work, that you did not consider to be advancing the state's case. It may advance the defense case,
yes.
But that's not what I'm dealing with. We're dealing with a particular issue. We say this is the main thrust of 99% of the charges against Thales, that they were aware, and that therefore they act in common purpose. We can't find those documents in order to prepare on it. And we would have thought, but we don't know, that the answer comes back, what you have is what we have, then it's the end of that matter.
But they said they're going to respond to your request by the 17th of August.
That's fine, my lady. All I'm saying, I don't want an impression that we're holding back a request for further particulars. In fact, we've done it in a different format to resolve the most pressing problem already in February. So we're cooperating. There was one other outstanding issue, and that was the Constitutional Court application. The withdrawal of that has been finalized today. We've already served to the State Attorney because you need consent for them to withdraw. So that's also out of the way. But from the Thales perspective, we're not holding back anything. The only reason that there is not a formal request, we wait to see if those documents would maybe answer and obviate the request or curtailing the request. And then whatever your ruling is today, we just go with it. It's fine from Thales' perspective.
Thank you.
Thank you, madam.
Thank you, Mr. Wu. Mr. Downer?
Please talk, my lady. Just some replies to my learned friend for Mr. Zuma. The issue of the trial date in October, for which all parties sought your directive, is precisely as your ladyship put it, that we can't choose that trial date until this matter is certified as trial ready.
Yes.
And when this matter is certified as trial ready, whether it be at the end of August or during September, or indeed even in October, when it is so certified, the period we need from that date to setting the matter down for trial cannot simply be a month. Even 2 months.
Well, that's not for me. That's why I said to you, that's premature
Yes.
at this point in time for me to say anything about the trial date. because it has to be certified trial, and whichever judge is dealing with it on that day will obviously apply his or her mind to that issue. But what I said to Mr. Skakane, and which I think might be in the light of his acceptance or concession, is that what you propose, that this matter only be adjourned to October, I am not happy with that. I want a date before that, so that, because the longer you delay, having this matter a certified trial delay, the longer you delay getting a suitable date for trial. And it's in the interest of, I think, all parties that this matter be heard as soon as possible. So go ahead.
Absolutely, Madam. I agree with everything the court says, and indeed with everything my learned friend said. We all want the trial sooner than later. But we can't be driven into a corner, that's all I'm saying.
I don't think you will be.
Yeah, and your ladyship has given directives
Yes.
by the exchange we're having now, and for that we much appreciate it.
So I wanted to, I'll put this to you, that in my view, a date in early September, so that by then all the requests could be dealt with. I then will urge the first and second accused, if they wish to request further and better particulars, to do that in time, so that on the date to which this matter will eventually be adjourned, you won't have any further issues. It will be a date on which perhaps the parties can just curtail proceedings by dealing with the issue of admissions that could be made, etc., and thereafter set down for trial. But what about this racketeering issue? That's concerning me now.
Well, Melody, that's one of the things we put in our papers. I mean, and we only learned of that
Yes.
relatively recently, I think last week. My learned friend.
What's the state's attitude to that?
Well, obviously we haven't received the application.
Because that might affect the whole proceedings, the dates, and all of that.
Well, quite. And we know from these things, we tried before in this matter on numerous occasions when appeal proceedings are instituted or applications or appeals further up the line to the SCA and XCC. We try to think that it could be accommodated.
This is a review application.
I would imagine that it would be. It's probably a civil application, I don't know.
So then it will depend on whether you will get an early date for a hearing in the civil matter.
Yes. There'll be an exchange of papers, they'll file, we'll have to answer, they'll have to reply, we'll have to do heads of argument. Court will have to be allocated, the JP will do so. The JP has always done it on an accelerated basis, even with the best counsel and the most accommodating JP. And all of those
and this is going to, this really...
It's, and that we say that is our worry, and we have no control over it. We would prefer it otherwise. It's unfortunate that it comes now when Thales have had the papers since the year dot, and nothing's changed really. In the permanent stay application, all the state's documentation and memos relating to the issue of the poker certificate, etc., all there. No case has been more transparent than this. Inside of the NPA is apparent in newspapers, in courts, everywhere. There's nothing secret. So it's a bit surprising, but nevertheless, if that such an application is brought, so be it. And we'll have to deal with it. So that is another reason, along with the many other reasons, that we're putting on record now that even if your ladyship rules, as I think it would be a sensible ruling, to shorten the proceedings, put the state on notice and say, hey,
Yes.
by September you must now get your ducks in a row and get the papers out.
Yes.
We'll move heaven and earth to do that. Even that being so, and even if in the event that the court at that stage, even in the unlikely event that the court certified as trial ready, but let's hope they do, let's hope the court does, even then we would probably say at that date, as we're saying now, October is too early. Because from September to October to set a big trial in the High Court in the middle of COVID with 1 month's notice.
Well, that you'll have to address to the court.
Yes, but I'm putting on record now,
Yes.
just as my learned friends are putting on record, they want October.
Yes.
So come September, we're going to have a huge argument. We want October. We say, we told you we're not ready in October. The court will rule.
Well, I think circumstances might overtake it, and those circumstances might well be the review proceedings.
Yeah.
Because I cannot anticipate that you will get an urgent date for the hearing of the application. So unfortunately, that's going to put a spanner in the works.
unfortunately. We will assist, as we always have, to get early dates and to move our papers quickly as possible. We've been quite good. All parties have been quite good in that respect in this matter, since it's been. But even with the best counsel, the best judges, these periods have to elapse and work has to be done.
All right.
So
Thank you. Okay.
I'm in agreement with your ladyship.
All right.
my
Thank
lady.
you. Mr. Roux, just on that aspect, why was there such a long delay in bringing the review application?
No, but it was not, my lady. I was
Oh.
trying to explain.
Yes,
In February, when we got involved,
yes.
we looked at the documents.
Oh, it was only
and
then.
we realized there's a problem, and then we started to ask questions and follow up and follow up and follow up. So it's
Okay.
not, there was no delay.
So how, you said you haven't brought the application?
No, we'll issue as soon as possible. That's why I said very shortly. But we
So
were
it's-
hoping.
It's a civil application, I would
It's a civil
imagine.
review application. We were hoping to get the information that we may have taken the application away.
Because then you
or-
would have had to approach the deputy judge president for a date.
Of course we would
Because
do
he's
that.
the senior judge in this division at this point in time.
Of course we would do that. We're
I mean,
very
that
keen to have
division
that
in
finalized
the
as soon as
Pietermaritzburg
possible.
division, yes.
Yeah, we don't want any delays, and we're very keen to have that finalized as soon as possible. But we didn't delay. We followed up, and we were waiting for the information from the state.
But even if, let's we don't have a crystal ball, but there might well be an appeal depending on the outcome of that decision. That's going to,
Yeah,
either by the state or by yourself.
yeah, it's difficult to look into that dirty crystal ball at this point. in
Yes.
time.
So that might be a further,
There's that possibility, of course, that we can't give
Problem.
undertakings, but
Yes.
not that we hope that it will happen.
all right.
But that's how
Okay.
that's how I can put it.
Thank you.
Thank you, my lady.
Mrs. Kakane, just this aspect, this review application, changes the complexion of things somewhat.
Well, it changes the complexion, but it also calls upon us to consider
Yes.
what the prejudice will be to us and whether the state shouldn't proceed with accused number one. But that's a matter that we will deal with when
with
that
the
arises.
trial.
But we may have to consider that because we can't be prejudiced. If we think it will prejudice us, we will take the appropriate steps at the time.
Certainly. All right. Then my ruling is we adjourn this matter. This will be to a date in early September. And on that date, hopefully the application would be launched and perhaps even heard if an urgent date could be secured. I don't think it's necessary, the parties can agree thereafter. If it's contentious, then I'm just concerned about the attendance by the accused in this matter. I suppose he'd have to appear, unfortunately, because if it's going to be a date on which a trial date is going to be set, he will have to appear. Unless the parties agree on a trial date. If they do so in consultation with each other, it may obviate the necessity of any further appearance, and the matter can then just be adjourned in absentia to a date. But I suppose on that date, parties will have to be present if the issues can't be resolved, other trial issues. So it's September, it will be. Second week in September. If you have a diary and give me a date that's suitable to all parties, I'm going to adjourn this matter to that date.
Lady, we usually do an appearance on a Tuesday to accommodate travelling. So Tuesday, the 8th of September might appear.
Okay, let me hear what
A
Mr.
date.
Roux has to say. Is that
We concur with that.
you'll accept?
That's also suitable for us, thank you.
All right. All right then.
My lady, there's one aspect that I should bring to your
Yes.
attention, and that is for the 8th. We don't know what the position is with COVID and international travel, so we just put it on record. You would see that the representative
Oh
is
yes.
also not here
Oh,
today.
yes.
We have discussed it, and there was some agreement, but I just can't give an assurance they will be able to travel by then.
All right.
But I assume that we can then it's a telephone call away to resolve this.
Yes.
Thank you, my lady. It's just on record that there's no disrespect.
Thank
Thank
you.
you.
Well, my lady, I don't know if your ladyship is going to issue the order now and then adjourn, but there is just the issue of the amended indictment. I don't think it's a problem. I haven't had any objection from my learned friends. I'll ask your ladyship. Just
What
to
about
order.
the indictment, Mr. Downer?
My lady, we've added to the 783 payments 6 additional payments and 2 credits. So and anyway, so instead of 783 payments, the schedule now reflects, or the application is to substitute the schedule so that it's 791 payments, and the extra 6. The
Well-
amount goes up slightly.
Well, I wasn't, I think in my communication, that issue, I asked if there's going to be any applications, etc., and he said there were none.
But it's in our
So
picture.
I'm not sure if there's going to be an objection to the amendment, or Mr. Skakani?
We'll see it when it comes. I think
Oh,
it's,
you'll determine it.
yeah, I mean, my learned friend says it's all this big media thing. There's now new ones. It's old ones. It's old that they should have picked up, actually.
So then there will effectively be no objection then to the addition?
I can't take a
You
position.
can't tell me.
I can't take a position.
All right, then, I think you'll have to serve the amended documents and then take it from there, Mr. Downer.
Yeah, we have done so.
Oh,
my
you've
lady.
done
Yeah,
so.
on my lip. So I would ask the court's
obviously,
ruling
Mr.
that
Skakane hasn't perused them yet and discussed it with his client.
as it pleases the court.
Okay. All right, then, you said the 8th of September, Mr. Zuma. Your matter's adjourned to the 8th of September. And unfortunately, you're warned to be back here in this court on that date. Thank you. Is that the roll?
That's the role, my lady. I'm indebted to the court.
Court is adjourned.
Okay.